Welcome to the meeting I guess we've all been waiting for, which is clause by clause consideration of Bill S5. I'm told all the sound checks have been done and have been done successfully.
I haven't had a sound check, Mr. Chair.
Can we? Pardon? You're good, apparently.
Excellent.
Yeah. So we have with us from the Department of Health, Greg Garreau, Director General, Safe Environments Directorate. From the Department of Environment, we have Mr. John Moffat, whom we know very well and has been very useful to this committee on a number of subjects. Assistant Deputy Minister, Environmental Protection Branch. Laura Farquharson, Director General, Legislative and Regulatory Affairs, Environment Protection Branch. And Jacqueline Gonsalves, Director General, Science and Risk Assessment, Science Technology Branch. So welcome back to the committee, to all those from representing departments today. So I guess we'll just get the ball rolling. And
Monsieur le Président.
Oui.
Mr. Chair, before starting the clause-by-clause study, there's a number of irregularities or points that need to be clarified, maybe with our legal specialist who's here, in terms of what's written in S5. It's the way in which it's said. I'll give you a specific example. On page 2 and 3 of the bill of S5, so I have the French version. At the bottom, around line 45, so on the English side, there's A, and then it's really, it's A, and then I, and I. But in the French, it's all in one, so it's harder to read. I was wondering if that needs to be corrected. One moment, please. I'm saying we are going to be taking our time, so it is complicated, the clause by clause. I'm just warning you. Apparently, that's normal because it's not a translation as such. It's that we do have a, there are, one legislator creates the English version, one creates the French version, and so there are different models that are not completely identical, so it's not an error. So I understand that there aren't consequences. So on page 4 and 5, then there is the I and I on page 5 on both sides. But there are other places in the bill where it's ABC and it's not exactly the same. So just to know whether there are any consequences to this. No, it's true. It does seem to be a contradiction. But I'm told that I should maybe ask the people who are present here why there is this difference. I don't know if anyone...
On page 2, Article 3.1, we go 3.1a in English, 3.1a in French, but in English we then go 3.1a I, or whatever, small Roman numeral 1. But that is not reflected in the French. Is that normal? Does anyone want to... Should we just, our legislative clerk, yes, go ahead.
I'm just wondering, I think Laura Farquharson may be able to respond to that. Laura?
Yeah, and I'm just trying to look at what you're looking at quickly, but I do believe that is it's a drafting customs, that it's written one way in English and one way in French, just different.
Because as Madame Posé points out, when you go to page 4, clause 511D, there they are identical in their formatting. Maybe.
Okay, well, I can't answer that.
That's fine. That's fine. That's fine. Maybe is there a way that we can after this meeting we can verify if this is an error? Or?
Well, of course, but I think you just have to take it that
on faith
that the Justice Department drafted this properly and went through the Senate, and this is the form. And as I said, there are different conventions.
Yeah, and it got through the Senate, so. The Senate saw it before and didn't pick up on this, and apparently we just have to trust the Justice Department on this. And pardon?
Mais peut-être, Monsieur le Président.
But perhaps, Mr. Chair, at the Senate, there's not a francophone who's as tiresome as I am. Well, it's not a question of language, actually. It's the way of structuring it is not always the same in both official languages. So I think we'll let it go if you don't mind, because it's really outside of what we're doing. I just wanted to know whether there are any consequences to this. Apparently not, because it is easier to read when it is split up. Yes, it does seem to be a contradiction later when it is divided into subparagraphs. So we have to set aside Article 1, or Clause 1 rather, which is the short title. We'll come back to that at the end. So we'll start with Clause 2. Would someone wants to propose NPD 1 amendment? NDB, rather.
Mr. Chair, and the amendment reads that Bill S5 in Clause 2 be amended by replacing line 10 on page 1 with the following. It starts with ERY, individual in Canada and future generations have a right to a healthy environment. And really the addition here is adding future generations. We heard from a number of witnesses that giving future generations the right to a healthy environment is important. We heard this from young people, from First Nations leaders, and I hope that the committee will support this.
Okay, debate.
Oui, Monsieur le Président.
Yes, Mr. Chair. It's not the form, but everything relies on words in laws. I don't know if my colleague, Madame Posé, has that same. It's the first thing that, in French, it's tout particulier is used in French to identify human beings, but I think person would be more appropriate. But I don't want to challenge the authority of the translators. But I think that Madame Posé might agree with me. But as for the meaning, yes, everyone seems to agree. But before saying yes, particulier, it's a strange formulation. So could we? Is this a friendly amendment if we say that we recognize that every person is better than individu, personne is better than individu? So we'll take a short break so that I could give you the proper clarification on this matter. Apparently, in bills, the concept of a friendly amendment does not apply, but you can propose a sub-amendment. So I don't want to begin a specific case. So you'll tell us what you would like. This is the sub-amendment would be the following. In the French version, that the word particulier be replaced by the word personne. So individual by person. Do we want to debate this sub-amendment? Do we have to have a recorded vote on this? So I think we can vote on division. Do we agree? Yes? All right, we agree. So congratulations. My first amendment has succeeded. No, a vote. So, Mr. Clerk.
The sub-amendment, Mr. Dogood.
Opposed, Mr. Chair.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Non, est-ce qu'on votait sur le sous-amendement?
I'm sorry, are we voting on the sub-amendment or on the amendment?
That's what I'm trying to figure out.
Against.
Thank you.
But what are you voting on?
Sub-amendment.
Okay.
And then we'll vote on the main one.
Okay.
So it's a
So no,
sub-amendment for
yeah.
French.
So we're voting on the sub-amendment. Mr. Dogood is against. Go ahead, Mr. Clerk.
Ms. Taylor-Roy on the sub-amendment.
4.
Ms. Thompson.
Against.
Mr. Weiler.
Against.
Mr. Benson.
For.
Monsieur Deltel.
Pour.
Mr. Couric.
4.
Mr. McLean.
4.
Madame Posey.
En faveur.
Ms. Collins.
4.
Yeas pour 6, nays contre 4.
Monsieur Deltel. Alors, on va voter maintenant.
So now, unless we want to debate the substance of the amendment, we are now voting on amendment NDP 1 as amended.
One of our witnesses has his hand up, and I'd certainly value the
Go ahead,
input
Mr.
of our
Moffat.
experts.
Mr. Moffat.
Mr. Chair, just point of order.
Yes.
Did you call the vote already? Are we allowed to go to witnesses after? Call the vote?
Did I call the vote? Pardon? No, apparently I didn't call the vote on the amendment. We just had the vote on the sub-amendment, and I was going to call the vote on the amendment if there weren't anyone interested in speaking to it, but Mr. Couric is. But excuse me, before Mr. Couric asked that Mr. Moffat give his opinion on I guess the amendment. Mr. Moffat, you're on mute.
Can you hear me now?
Yes, we can. Yes.
Okay, apologies. So, and I apologize for not intervening before the vote. I think I was on mute. I just want to point out that the consequence of changing the terminology from person from individual to person means that this right would be extended to corporations as well as people, and that was not the intention of the government in introducing this right. The term person in common law has a broad interpretation and includes corporations as well as humans.
Okay, thank you for that. Ms. Collins on the amendment.
I'd like to propose. Well, we've already voted. Oh yeah, on the amendment itself. I'd like to propose a sub-amendment to change in the French version not it back because I know we're not allowed to do that, but rather than saying.
Moment, please, just a moment. Could you hold that thought just a second? I'm going to consult the legislative clerk. Apparently, you can't sub-amend your own amendment.
Oh, well, I maybe would just put a.
But you could give the idea to somebody else.
Yeah, put an argument out if someone wanted to make it all people in the French, and I'm sorry, my French is not strong enough, but rather than every individual, say all individuals, so that we're not voting on the exact same sub-amendment, but that we could return to the language that would not extend this to corporations.
Okay, just a moment, please.
Individu, par individu.
Heureusement, il y a une solution. Heureusement, il y a une solution. Par consentement.
Fortunately, there's a solution. By unanimous consent, we could go back to the original text. Mr. Chair, I don't want to start a war of words, but the Larousse says that it is a human being, but I don't want to confront Mr. Moffat in that way, because I think he has has dealt with many more bills than I have. But that's the word I found most appropriate, the word person. But apparently the word person, that would include corporations legally. But the dictionary definition refers to a human being without distinction. So if there is another definition, I have no problem. I'm not going to fight for a word, but it seems to be that it's the word that relates to what we're saying. But we know that in law, I'm not a lawyer, but in law, the word person, personne, has a particular interpretation, a particular meaning, a moral person.
Yes, Mr.
So it's codified in law.
Okay.
That it gives that broad interpretation.
Shall we see the article in French, please?
Mais même à ça, si on change.
But even then, if I've understood after having consulted our legal analyst, we are playing with fire because there are consequences. If we change a word in a bill, it can have cascading effects, and we can really create problems if we do this. So I'm ensured that the word particulier covers persons and not corporations or legal entities, what we call personne morale in French.
To know if we have unanimous consent to.
We're working on that. We're working on that. We're working on that. I think.
Could we test the room?
Well, before I say yes, I'm going to ask some advice. I'd rather wait before I test the room, Ms. Collins. Ben, si on a le consensus.
If we have unanimous consent, we can leave the word as it is in the amendment. So I'm ready to come back. But when you look at the definition of Petit Robert, which I have here, which one do I have? It's the Larousse, which is used and for a person and something, and especially concerns someone, which is distinguished from something. So we're very far from the individual, from the human that we want to protect and the children to be born. Apparently, there is an interpretation act on interpretation of federal laws, which gives another meaning to these words. But I will ask Mr. Moffat to speak at the moment because he is the expert. And as you say, there are many, he's worked on many bills. Mr. Moffat.
Up from before, or is it new?
It is new, but I'll wait for Mr. Moffat.
Thank you. Mr. Moffat. You're on mute, Mr. Moffat, I think.
Sure.
Yeah, we can hear you now.
Okay. So under the Federal Interpretation Act, unless a term is explicitly defined otherwise in a statute, then it is to be defined according to the Interpretation Act. And the Interpretation Act provides that the term person in French and English has the broad definition that I just described, where that includes, I'm not sure what the term is, I think it's body corporate as well as a human. And so if we insert that language into this text, then we would be acknowledging a right held not just by Canadians or people in Canada, but also by corporations in Canada.
Donc, ça me semble assez clair si on...
So it seems quite clear. If we want to use the word person, then we're giving rights to corporations and entities. And I don't think that's really our objective here, or the bill's objective. So this is what Mr. Moffat has been telling us, is that we have to refer to the Interpretation Act. So it's not the Larousse that has the last word. Mr. Moffat, can you tell us then the definition of the word particulier in federal laws? It's not the first time that we're talking about human beings in federal laws. So how do we define what is the French word used to refer to a human? Is it particulier? Is it individu? We understand that it isn't person. Can you give me the word used in other federal laws to identify human beings? And we can use it right away. L'expression particulier, c'est le mot utilisé par le rédacteur. C'est la terminologie qui a pris qui existe dans le texte français. Oh, sorry. Apologies from the interpreter.
Okay, so can we resolve that, and then we'll get back to Mr. Moffat. Can you hear me in French, Collins? Pouvez-vous m'entendre en anglais maintenant?
Can you hear me in English? Apologies from the interpreter.
Mr. Moffat, back to you.
Okay. So the term particulier is the term that the Department of Justice drafters used in this amendment, in drafting this amendment. It is a term that is also already used in other provisions in the existing CIPA to refer to humans. So it would be a consistent usage of the term throughout the Act.
So what you're saying, Mr. Moffat, is if we go with personne instead of particulier, we have to bring in another CIPA Amendment Act to amend all of CIPA as it stands now, because that's the term they use in CIPA.
if there's any way to back to particulier.
Yeah, okay. We understand. We understand. That was a rhetorical question. Okay.
Monsieur le Président, je fais motion pour que...
Mr. Chair, I want to present a motion that we come back to the decision that was taken that were clear for reasons that were clearly explained. So we go back on that decision that was taken by unanimous consent. So we accept it.
Merci, Monsieur Deltel.
Start over.
Okay. So now we vote on the amendment as is, not as amended.
Mr. Chair?
Yes.
Oh, can I ask for some commentary from Mr. Moffat on this?
Well, we just...
The motion has been, the amendment has been tabled, and I just wanted to ask a question of Mr. Moffat.
Oh, yeah, of course, but we're dealing with particulier.
We're dealing with the
original. That's what I was saying. Yeah, yeah. Okay, go ahead and ask your question to Mr. Moffat. Well, wait a minute. Ms. Collins, you had your hand up, right?
It's irrelevant now.
Okay. Mr. Duguid, you have the floor.
Could you tell me where we are, Mr.
Yes,
Chair?
we are basically at the very beginning where we're voting on the amendment, which has been
put forward by Ms. Collins.
Which has been put forward by Ms. Collins.
The amendment is now, the sub-amendment is now off the table.
That's right. It's
okay,
done.
Good. I wasn't sure that...
Yeah, we're back to the original NDP 1.
Okay.
So you want to ask Mr. Moffat?
Yes, Mr. Moffat, I think your advice on the addition of the NDP amendment regarding future generations is to not support the amendment. I wonder if you could give us your advice on this and why we should or shouldn't vote for it.
So I think my role is to explain the consequences of the amendment. And in this case, the amendment would change the scope of the right in the bill considerably. And it's contrary to the entire approach that's been taken in drafting these provisions. The bill proposes that the right would be acknowledged for all individuals living now. We need to draw a distinction between recognizing a right that current generations, that future generations hold, and versus what is in the current text, which is acknowledging that the current generation needs to take into account the needs of future generations. That provision and that concept is in the bill. What is not in the bill and would be changed by this amendment would be to accord a right to people not yet born. That would, as I said, significantly change the nature of the right and diverge considerably from the government's intent in this case.
Collins.
Yeah, I guess I would just refer people to the United Nations document on a call to action for human rights of future generations. And they talk about the interlinked crises of climate change, environmental degradation, loss of biodiversity, and pollution as violating the rights of people every day, countless people, but also that this threatens the effective enjoyment of human rights of future generations. And this call to action really recognizes that climate actions are impacting people today, and they will also impact future generations. And we've heard that from numerous witnesses.
Would anyone else like to speak to this amendment? Ms. Collins, can you take your hand down? Anyone else? Okay. Il y a personne là qui veut intervenir là?
So no one wants to speak to this?
What?
So we will have the vote now. Please go ahead, Mr. Clerk.
Vote on NDP, or shall NDP 1 carry? Mr. Duguid.
Opposed, Mr. Chair.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler. Mr. Deltel.
Contre.
Mr. Kirk.
I'm opposed.
Mr. McLean.
Oppose.
Madame Posey.
En faveur.
Ms. Collins.
In favor.
Yeas pour 2, nays contre 9.
Okay, so the amendment is negative. Is that the term? Yeah. Good. Not good that it's negative, but good that we got through it. Good that we got through it. Go now to Ms. May as an independent. Her amendment is deemed moved already, and she has a right to a brief comment on the amendment that she's proposing.
I'm sorry, Mr. Chair. May I please correct you with all respect? I'm a Green Party member of Parliament.
I'm sorry. I didn't mean it that way, Ms. May. Yes, I know. I meant.
Check the map of the House of Commons. It seats us together.
No, but I meant like yes. I apologize.
No, it's okay.
But it doesn't change the fact that it's already been deemed moved.
Yes, and that's due to the terms of the motion passed by this committee that reduces the rights I would otherwise have. Just to clarify that for all members, I'm here, and I know at some point, because I have many amendments, some of you may regret that without really knowing what you were doing, you passed a motion that says that members of parties with fewer than 12 MPs or independents must show up with their amendments at clause by clause, even though we'd have the right to present them in the House as a whole, but for the motion. So this one is a fairly straightforward and small amendment. I hope that it might be acceptable to the committee. What Parti Vert 1, my first amendment, proposes to restore what has been in the Canadian Environmental Protection Act for decades, which is the concept of virtual elimination of a toxic substance. We argue from the Green Party that virtual elimination of toxic substances should remain within the Canadian Environmental Protection Act. We know there have been problems with the implementation of this act, of this concept of virtual elimination, but there are ways to ensure that virtual elimination of toxic substances from commerce be restored. I have additional amendments through the bill that makes this more workable. And I know I have very little time under the terms of the motion to explain it fully, but I think members of the committee I hope, are familiar with the arguments made by the Canadian Environmental Law Association that removing virtual elimination weakens the act.
Thank you, Ms. May. Would anyone like to speak to this amendment?
Mr. Chair?
Yes, Mr. Couret.
Thank you very much, Mr. Chair. I'd ask if any of the officials would have any, and I think this is going to happen just as a preamble to my question, Mr. Chair. I think because this is an extremely technical bill, I expect that a question you'll hear often is asking officials to expand on the impacts of some of these amendments, as especially the paper that I printed off. I felt almost guilty of a sin printing off so much paper for an environmental bill, but so my preamble being that I suspect we're going to hear often if officials and the drafting folks and the legislative clerk and the clerk to weigh in on some of the impacts of what these amendments may or may not include. So with that, Mr. Chair, I would ask if Mr. Moffat or other witnesses, if they would have any insights to share relating to the separate amendments, but specifically PV Parti Vert, if I'm saying that correctly.
Well, I'm happy to, Mr. Chair, I'm happy to provide an explanation.
Yes, please do so, Mr. Moffat.
So MP May is correct in that the bill would slightly amend the preamble, essentially by removing reference to virtual elimination, because virtual elimination is defined in the current CEPA, and there is a codified set of requirements regarding virtual elimination. As she explained, the implementation of those provisions has proved unworkable despite 2 decades of effort, and there is a new approach proposed in the bill that would expand on virtual elimination, retain the emphasis on a default preference for prohibition for a broader set of substances than are referred to in the current virtual elimination regime, and defining that group of substances as substances of highest concern. So in order to avoid confusion, by retaining the reference in the statute in one place when we're removing it in all other places, the proposal is to remove it from the preamble while retaining the overall emphasis in the preamble on the need to control and manage and prevent pollution and waste. And I apologize, I said highest concern. I think the term is slightly different in the Act, but we'll get to that provision later. The point is that there is now a new regime that is broader than virtual elimination, that focuses on giving a preference to eliminating those substances that are the worst, posing the worst kind of risk. So it's broadening the concept in that, but deleting this particular term throughout the Act in order to avoid any confusion.
Anyone else? Okay, we'll call the vote.
May I be permitted a comment?
Unfortunately not. I've called the vote, and
I had my hand up, but it's okay. I had my hand up to make a comment before you called the vote. But I
understand. But also,
and I'm not sure I'm allowed to make comments.
Well, that's the thing. It's
the problem is sorry.
You were afforded some time at the beginning to speak to the amendment, and I believe I was quite liberal in that respect. But we're going to go to the vote now.
The vote is on shall PV1 carry. Mr. Duguid.
Opposed.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler.
Against.
Mr. Benson.
Opposed.
Monsieur Deltel.
Contre.
Mr. Couric.
I'm opposed.
Mr. McLean.
Opposed.
Madame Posey.
Contre.
Ms. Collins.
In favor.
1 yea are pour, 10 nays 10 contre.
So the amendment is negative, and we'll go now to Amendment G1. Who would like to propose that? Move that? Yeah, Mr. Duguid.
I would like to move that, Mr. Chair. Want me to provide the rationale?
Yes, please. Well, if you wish, yeah.
Unless members have any questions, Mr. Chair, I would just let my motion stand.
Are there any? Does anyone want to comment or raise a question? No, Madame Posey.
Oui, d'abord, si je comprenais pas qu'on n'avait pas.
Yes, well, I didn't understand that we didn't have the English version. And then the other thing I discovered when I read this amendment is that everywhere in the Act we talk about the cautionary principle. And there we looked in, or the precautionary principle, we looked in the dictionary, we looked at history. So in French, we will take the principe de précaution. That's what came out of the Rio summit of 1992. So the language was used in other public policy, but in French, in the Rio generation, it's the principe de précaution. And I had looked for something in PMRA, and they talk about the principe de précaution, and they say if there are serious or irreversible risk, the absence of risks should not serve as a pretext to delay further the adoption of measures aiming to prevent the degradation of the environment. So to change the word prudence to précaution, because if you look at prudence, it refers to accounting principles. It's one of the great accounting principles. So that's what it refers to. So the principle of prudence or caution doesn't exist for the environment. We always talk about the precautionary principle.
Sorry, Mr. Chair, sometimes the interpretation runs longer, and did you call my name?
I did, yes.
Okay. I guess not on Madame Posé's point, but on the motion itself, this seems to change the French version to be more along the lines of cost-effective instead of effective. If like my French is not strong, but that's my understanding. And I guess in my opinion, I think the language of effective seems much more in line with where I'd like to see this bill go, rather than solely focusing on cost-effective.
Mr. Duguid.
Well, thank you, Mr. Chair. And in the spirit of giving a full explanation, I'm proposing this amendment to respond to the Other Places Amendment to the precautionary principle formulations in the preamble. And in Section 2(1)A of the Act, the ENVI Committee of the Senate, as you know, amended the English version of the subparagraph 2(1)A II to remove the word cost from the phrase cost-effective measures in an attempt to better align the English provision with the French provision, which simply refers to mesures effectives. However, the discrepancy between the English, i.e. cost-effective measures, and the French, mesures effectives, is not a translation error and, in fact, is consistent with the English and French versions of the 1992 Rio Declaration on Environment and Development, upon which the provision is based. In order to avoid misalignment and to ensure the key notion that precautionary measures be cost-effective remains in SEPA, the government proposes to correct the purported translation error by amending the French version of the Act rather than the English. That was a long explanation, Mr. Speaker, but Mr. Chair, but I hope that clarifies things.
Thank you. Anyone else?
Oui.
J'ai Madame Posé, ensuite Monsieur Deltel.
Madame Posé and then Mr. Deltel. Yes, I understand what Mr. Duguid is saying in relation to his amendment, but I don't think he answered my question about the precautionary principle rather than a principle of caution or prudence. So I will bring a definition as it was defined in the Rio agreements. What I don't like about the G1 amendment is postponing to later the adoption of mesures rentables, effective measures or profitable measures. Is that what it means? So that word means that I would vote against this amendment, which is supposedly a correction of the French version. Mr. Deltel? So I always come back the word rentable. For me, it's more efficace. So now I would like to call on Mr. Moffat's knowledge to give an answer to the idea proposed by Madame Posé to change this word prudence by précaution. Given that we're changing words, you were very convincing a few minutes ago, so I appeal to your knowledge. Do you consider the word précaution more relevant than the word prudence? maybe I could answer this question. And we always rely on our colleagues at the Department of Justice. And in this case, prudence is used in this context. And I think that that is the word, the proper word here, and it's also used in other contexts in federal law. So you're talking about federal law. Are you talking about this act or other federal acts referring to the environment? Because Madame Posey's argument is relevant. She explained earlier that this refers to the Rio Agreement, and that's the word that was used. And if we are consistent when we talk about environment, well, there is a historical justification. Yes, that's true. Yes, please go ahead. It is used. The word prudence is used in the CEPA Act and in other translations of the for the principle. I think it's 76.1, for example. Yes, we're in the preamble now. So it's the word that was used in the original act. Mr. Duguid.
Mr. Delta asked my question. Thank you.
Okay, Madame Posey.
Madame Posey. Yes, I agree with Ms. Farquharson with what she has said. Yes, we went and looked in the 1999 Act, and that's the expression that's used. But I'm saying at that time that might have been the expression used, and Rio just was 7 years. But when we talk about the principle in environmental laws, it's the precautionary principle that's presented, principe de précaution. And also for mesures rentables, I think in English it would mean cost-effective measures. That's the text. And in Rio Accord, that's what's used. I didn't find that very pleasant as a translation to say effective in French. But so if what's good for the goose is good for the gander, if I want to work on getting the principe de précaution, I don't like effective, but I'll accept it because Rio uses effective in French. So I will file an amendment on that. And we can keep using an error from 1999. We have to be consistent with what the government signs at the international level. But now we've been discussing the amendment. Are there proposals of sub-amendments on the table? Yes. I changed the word prudence by précaution. But we also talked about the rentable word. But your sub-amendment is to change prudence to précaution. And also, if I can do it, I would like to change rentable by effective. But for the moment, we will just focus on prudence. Mr. Moffat.
My understanding.
Yes, Madame Posey would like to substitute the word précaution for prudence. But I see Mr. Moffat has his hand up, and I thought, you know.
Mr. Chair, I just wanted to make the observation that these terms have been used consistently in multiple federal statutes since the Rio Declaration, in the manner in which they currently appear in CEPA. One consequence or possible consequence of amending CEPA on this definition would be that it would call into question the meaning of the other statutes or the intention of other statutes that retain the original Rio terminology, which in turn could have unintended implications for the intended requirement in those statutes to exercise the precautionary principle in decision making. So, from a government statutory consistency perspective, it would be our recommendation to retain the same terminology that has appeared in all federal statutes since 1992, and that has not been subject to challenge and has enabled officials and decision makers to exercise the precautionary principle consistently.
Mr. Couric.
Thank you, Chair. And so being that my French is far from passable, and this is a unique amendment because both the English and the French amendment is both in French. Mr. Chair, my question to the experts and possibly the mover of the motion is if this is not if this sub-amendment, so changing that one particular word, is there an impact on the rest of the bill? Is it setting a precedent that would require that particular word? So if I'm following the conversation correctly, le prudence, excusez, but it's would that be required to be changed throughout the entirety of the act? Would this have implications? And I think what Mr. Moffat was inferring is that if it starts here, then the consequence would be the entirety of CEPA, both what is amended and what is not, but also related acts. And I know some of the witness testimony that we had heard talks about this being one of a number of acts related to environmental regulation, whether it be in agriculture, health, pharmaceuticals, that sort of thing. So I guess my question comes down to if that word is changed in this amendment in en français, does that have wide sweeping consequence across the entirety of this and possibly other acts?
Mr. Moffat.
So the short answer is yes to CEPA and to other statutes. Certainly in CEPA, the terms appear at least 4 other times, and in some cases in provisions that have not been amended by S5 and that are therefore not open to this committee to amend.
Okay. Any more? Mr. Moffat, could you take your yellow hand down so that anyone else? Madame Posey.
Écoutez, je veux revenir parce...
Listen, I want to speak again because this dates from more than 20 years ago. I want to correct that what might have been a translation error at the time, and I'm remembering what could have been an error of translation. Rio was in 1992. This was in 1999, and there was maybe a error in terms of translation. I don't understand. We're not able to correct. It's very rigid. Federal laws are very rigid. We can't correct an error that dates from more than 20 years ago. Regardless of the legal argument I'm given, I'm saying we signed the Rio Agreement, and I'm asking that our act, our Environment Act, be aligned with the international agreement, which doesn't use the term principle of principe de prudence, but talks about the principe de précaution, which is an environmental expression rather than a accounting expression. Ms. Collins.
Did you call the vote?
No, I'm asking Ms. Collins.
Oh, I see.
And she's waiting for the translation. So.
I was. Thank you, Mr. Chair. Thank you to Mr. Moffat for that explanation. I just want to be very clear because in general, I think I support Madame Posey's change, and I also, oppose the kind of intention of the original motion, and would much prefer us change the English version to effective rather than cost effective. But from what I'm hearing, if we were to do that, we not only would have to change the rest of a number of areas in this act that we can change, but there are areas in this act that we're unable to change and then would be inconsistent. Just wanted to make sure that I'm comprehending that correctly. Mr. Moffat, can you just clarify, did I get that right?
I'm suggesting that in order to be consistent, that would be the appropriate consequence, so that the same terms are used consistently throughout the Act and then ideally throughout all federal statutes.
And just for this Act in particular, if we were to go and change everything from cost effective to effective and from la prudence to, and I'm forgetting the French word that Madame Posé had suggested, but if we were to do that for all of the areas that we can change, what is the impact of having that inconsistency with areas that we can't change in this Act?
I think the short answer is that we don't know, and so it would create uncertainty because you would have the same term defined in different ways in the same statute. I'm reluctant to speculate, but I think we can say that it would create some uncertainty as to the way in which the various provisions might be interpreted, particularly if they're subject to judicial review.
And I guess follow-up question, just to ask, I think changing this in all of the areas that we possibly could, and opening up some uncertainty, meaning maybe moving in the direction of effective versus cost-effective and the precautionary principle doesn't seem too dangerous to me. But I'm curious what is the danger that you see, or what is the negative repercussion of that uncertainty?
Well, I think the concern that I'm articulating is that we would have what was intended to be the same obligation associated with various decisions under the Act, now subject to different legal obligations, or at least differently defined legal obligations. And I think the concern is that if a decision made under one of those provisions was challenged in a judicial review, the fact that there are different definitions in the Act could lead to an unintended outcome. So I don't think I can point to a very specific implication other than the risk of uncertain outcomes as a result of what would be an inconsistent approach to precaution in the statute. And again, I remind you that this has not been, the definition hasn't been challenged, and the exercise of precaution hasn't been challenged to date.
Okay, thank you.
Sorry, Mr. Moffat. Could you tell us what other statutes this slight change here might affect, where prudence is listed as opposed to precaution? Because you're referring that there seems to be some problem that this will affect several other bills by being inconsistent. So it would be good for this committee to know which bills you're referring to.
Go ahead, Laura.
Yes, and so I'll say I don't think we've done a full survey right now on this particular question, but I believe that so we started out with, of course, this was under Rio that we used that prudence and the cost effective in English are used. I think it's the Federal Sustainable Development Act also uses prudence, and it's possible that other federal acts use. Canada National Marine Conservation Areas Act also uses prudence. Pest Control Products Act also uses prudence, so it is in a number of statutes. And I think that I would say that the cost-effective measures which is definitely how the precautionary principle is interpreted, is different from effective measures. And my understanding of the Senate amendment was we were not trying to change the concept, we were trying to get the translations right. So that is why I think that we would, that's why the suggestion for aligning, if the English is effective measures, meaning still cost-effective measures, then the French should align with that and say mesures rentables.
Madame Posey.
Oui, je reviens.
Yes, I'm back because in 1999, the Canadian government established that this concept, the precautionary principle, must be understood as follows.
Protect the environment and health are guided by the precautionary principle, which states that where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Ça, là, c'est exactement Rio, mais ça a été mal traduit en français. À l'époque, ça a été
That was from Rio, but it was wrongly translated at the time. It was translated as principe de prudence, but in English it's the precautionary principle. We have to correct it 20 years later. So we can't hear examples where it would have confused judges. So I say, well, let's clarify that. And later I'm going to file an amendment which will give a definition of what the principe de précaution is. And we'll use the Rio definition because that's the one that exists in English. So I'm starting to get angry because it's too much. We're really getting stuck for a word that has been clearly defined since 1992, where there was an error since 1999, and we're saying that well, maybe at some point the judges will make a mistake. Well, I'm sorry, I disagree.
Don't, technically speaking, as you know, you're permitted to speak to your amendments and so on. It is at my discretion. If it's very brief, what you have to say, because I know you were at Rio, so I will allow it, but very briefly, please.
Well, the precautionary principle, as read out by Madame Posey, was correct. And for benefit of committee members, the addition of the notion of cost-effective was not in the precautionary principle at Rio, nor was it in the Stockholm Declaration. It's not in our Oceans Act when precautionary principle is referenced, nor is it in the National Marine Conservation Act.
Thank you. Ms. Collins.
I was going to say something very similar to what Ms. May just brought up, just that, you know, in the precautionary principle in Stockholm, cost-effective isn't mentioned. And I do want to correct the record. The Senate committee clearly spoke to removing the word cost, and their rationale was so that we don't limit environmental protection. And so I think rather than reinserting this into the translation, I think we should actually just correct it in full and remove cost throughout. But that said, I do think it seems like there's likely a majority of committee members who might keep it in, and I would love if we could kind of move this along. And if we're on I'm not sure if Madame Posey had officially submitted her sub-amendment, but I think, yeah, I'm very much in support of it, and I would love to come to a vote if possible soon.
Monsieur Deltel.
La question s'adresse à nos experts.
This is a question for our experts. If the committee were vote in favor of the changement of the word prudence by precaution in order to respect the English expression, are there any impacts in S5 itself? Are there words referring to that which need to be changed to précaution rather than prudence in French?
You want to be on the speaking list?
Oui. Ce que je voulais peut-être juste rajouter.
Well, I wanted maybe to add to this. The issue is not to have the answer right away.
Then, oh,
Mr. Chair.
yes. While Mr. Moffat searches the bill, Mr. Duguid.
Mr. Speaker, Mr. Speaker, too used to getting questions in question period. I haven't quite made the transition to committee, but as many folks have already said, Mr. Kurek in particular, technical bill, we're parsing language here. It might be best, Mr. Chair, if we as I understand the procedure, to stand this matter so that we can sort it out. And I would, do I move that? Is that?
I'll find out.
Monsieur le Président,
Mr. Chair, if you'll allow me, because this is very interesting, but time is flying by. What I would recommend to our specialists is to come back to us at the next session to know if the word prudence is in the Act. They want to stand this down so that we can have some time to get the proper information, because we're really going in circles at this point. But listen, I would be ready to vote on that, and if the vote is positive and the committee agrees, well, people will do they'll check. But, that's noted, but Mr. Duguid proposed that we stand this down, so I want to, I need to find out how we can do that procedurally. So now I think I understand, but we'll see. Mr. Duguid proposed that we stand this matter down, so we have to vote on that. Do we need to vote on that? No? Does everyone agree to stand it down? There's a consensus, so we'll just postpone it.
The amendment in general.
Pardon?
Okay.
Clause 2, the whole clause.
The whole clause, oh.
But the sub-amendment is sort of in abeyance
we
now?
could get through one clause today, but... No,
It's in abeyance, the whole thing, yeah, okay. Okay, alors on va mettre ça de côté.
So we will postpone this. And now we get to NDP 2 amendment.
Clauses stood down, and so we're into clause 3 now, Mr. Chair.
Oh, okay. Okay, so we're on clause 3, amendment G2. Where are we now? Just a second. Easier said than done. G2, where's G2? Oh, yeah, right, because we're jumping over all these other ones. Okay, just.
Page 8.
Okay. G2 is on page 8. Would somebody like to move it? Yeah.
Yes, Mr. Chair.
Go ahead, Mr. Duguid.
Yes, Mr. Chair, I will move this government motion to respond to the other places amendment to the precautionary principle and 2(1)A of the Act. And once again, the ENVI committee amended the English version of the subparagraph 2(1)A2 to remove the word cost from the phrase cost-effective measures in an attempt to better align the English provision with the French provision, which simply refers to mesures effectives. However, the discrepancy between the English cost-effective measures and the French is not a translation error and, in fact, is consistent with the English and French versions of the 1992 Rio Declaration on the Environment and Development, upon which the provision is based. This does sound a lot like my previous intervention, Mr. Speaker. In order to avoid a misalignment and to ensure the key notion that precautionary measures be cost-effective remains in CEPA, the government proposes to correct the purported translation error by amending the French version of the Act rather than the English. And I don't know if we could get Mr. Moffat to provide some commentary again, Mr. Speaker. Mr. Chair.
Mr. Moffat.
I don't think I have anything more that I can add to the extensive discussion on this topic to date.
There's a lot of implications. Ms. Collins and Madame Posey.
Yeah, just kind of reiterating the fact that the Senate purposefully took out the word cost. And so the translation error here is actually should be switched if we were going to return to what the Senate had amended. And to go back to 1999, when the committee was looking at this issue for the 1998 CEPA bill, C-32, some liberals, along with some progressive conservatives, the NDP, and Bloc members succeeded in committee with an articulation excluding the word cost. But then it was overturned by the cabinet and the liberal reform folks that were support stage. So just a little bit of history of this. There are lots of people who want the word cost taken out of this. And again, notably, it is not in the Stockholm Declaration or in a number of the other ones that Ms. May had articulated.
Followed by Mr. McLean.
Yes, well, you will find me annoying. On the English side, I'm not going to correct Rio, but in the version that we looked at, it stated cost-effective. But in French, that is translated by mesure effective and not rentable. And we went to see in the administrative version, so for the application of this law, the federal government must, given the Constitution and the laws of Canada, and under reserve of paragraph 1, and exercise its power to protect the environment and human health, and later should not serve as a pretext to delay till later the adoption of effective measures aiming to prevent environmental degradation. And on the English side,
postponing cost effective. Je ne comprends pas pourquoi que là, on changerait la version française. Bon, moi, je garderais cost.
I don't understand why we changed the French version. I would keep cost effective, but in the Rio version that we saw, it said cost effective. But in French, it should be mesure effective, as it was in the 1999 version of the Act. So I would like to propose an amendment. Rather than mesure rentable, it should be mesure effective, even though I'd prefer efficace, but I won't dwell on that, to come back to the act that spoke about mesures effectives, effective measures. So you're proposing a sub-amendment. Yes. And one moment, I need to get some information.
Do you want to address the sub-amendment, or do you want to wait till, okay.
Could you repeat it, Mr. Chair?
Repeat what?
The sub-amendment.
Yeah, so we want to change rentable to effective.
Effective, oui. Ben, c'est ça qui est dans la loi.
Qui est dans la loi telle qu'elle
99, oui.
de 1999.
Application administrative, mission du gouvernement fédéral, 2, parenthèse.
That's what's in the act. So 2.1a. So now we're going to be debating the sub-amendment. Do any members wish to speak about the sub-amendment? Mr. Cork.
Sorry, Chair, I'm just hoping that we can clarify. So the sub-amendment would remove cost.
No, the sub-amendment is only to the French. It's only to the French.
What's the right word
Instead of rentable, the word would be effective.
Okay, so it's only changing the French. Okay.
Yeah, we're not changing the meaning of the English. We're just changing a word in French. Okay, so anyone else like to speak to the sub-amendment before we vote? No? Okay, I'm calling the vote on the sub-amendment to replace rentable in French by effective.
Mr. Duguid.
Je vote pour.
Mr. Longfield.
So I support.
Ms. Taylor-Roy.
Pour.
Ms. Thompson.
I support.
Mr. Weiler.
En faveur.
Mr. Benson.
Support.
Monsieur Deltel.
D'accord.
Mr. Kirk.
Support.
Mr. McLean.
Pour.
Madame Posey.
En faveur.
And Ms. Collins.
My Zoom disconnected for a moment, and I missed. Are we voting on the whole motion, or?
No, we're voting on the sub-amendment, which is to replace rentable with effective. It doesn't change the meaning in English.
In favor.
Should we apply this vote to the rest of the bill?
So, yeas poll 11.
No? Okay. No unanimous consent on that. Okay, so now we go as amended. Mr. McLean, you want to speak to it?
Yes, and thank you. I think much of the translation now will be cost effective from effective in French. But the thing about effective is it's a subjective term, and I think my colleagues around the table understand the more precision we get into this, the better. And a cost effective is actually measurable. So I do think it's important to change it back to cost effective. Thank you.
Anyone else? Two as amended.
So shall G2 as amended carry? Mr. Duguid.
Oui.
Mr. Longfield.
Yes.
Ms. Taylor-Roy.
Yes.
Ms. Thompson.
Yes.
Mr. Weiler.
En faveur.
Mr. Benson.
Yes.
Monsieur Deltel.
Oui.
Mr. Kirk.
Yes.
Mr. McLean.
For.
Madame Posey.
En faveur.
Ms. Collins.
Opposed.
yeas pour, 10 10, nays contre, 1 1.
So the amendment as amended carries. We now go to, let's just get my papers in order here. NDP, so we're going to 9, okay. NDP 4, who would like to move this amendment? I guess it's yourself, yes, Ms. Collins, go ahead.
And this language around the protecting the rights of nature comes from not only a number of organizations, but also a number of First Nations individuals who have been advocating to protect the rights of nature. Here, where I live on Vancouver Island in the Salish Sea, the Esquimalt and Songhees nations have participated in reconciliation dialogues, asking for areas to be protected, recognizing that nature should have rights that, in their opinion, that these are living entities. And there's also been a amazing movement around the St. Lawrence River as well, along with around the world in areas like New Zealand, folks who are advocating to protect the rights of nature.
Would anyone else like to speak to this? Mr. Longfield.
Yes, thank you, Mr. Chair. I wonder if Mr. Moffat could comment on changing from the rights of individuals to the rights of nature.
So my comment on this will be similar to one that I made earlier in the meeting, that this would fundamentally change the scope of the right that is articulated in the bill, which at the moment is focused on individuals, people, and it would confer that right on humans as the right holders, recognizing that nature or components of nature have rights on their own would represent a fundamental paradigm shift. It is not one that certainly the government has yet contemplated or thought through fully. More so, in addition to that kind of fundamental change in the focus of the right that would be provided by S5. The bill, as currently written, doesn't contain any supplementary or complementary provisions that would provide legal personhood or any corresponding procedural or substantive rights to nature. Where, by contrast, of course, the way we've articulated the right to humans is supplemented in SEPA already and in S5 with various additional procedural rights and additional substantive rights in order to give life to that new right that we have not provided for any such additional provisions related to rights of nature in S5.
Mr. McLean, followed by Ms. Collins.
Well, again, this bill, I think what we're trying to do is get precision around these definitions, and without a definitive precision around the rights of nature, I think it is as open-ended as anything we've probably considered in this House of Commons since I've been here. Thank you.
Ms. Collins.
Yeah, I want to thank the officials and other members for their comments. Really expanding rights and including the rights of nature means that we are acknowledging that they have the right in and of themselves to exist and to flourish. This is something that other countries have been doing, and I would be happy to work with officials to change other areas of the Act. We did skip through a number of sections in Clause 2, which have further amendments on the rights of nature, and hope that the committee would consider this really important move when it comes to protecting our ecosystems and natural communities.
Okay, thank you. Any more comments before I call the vote? Mr. Weiler.
Yeah, I'll just say I think this is a really interesting addition, and I don't think inserting this where it is right now will give it the, basically it's essentially what Mr. Moffat has said. I don't think it'll really give the right framework to put it into place. I think this is something that would be very interesting for us to study at the ENVI committee, perhaps for future studies, so we could look at what this would actually look like to implement in practice to really do it justice. But given the concerns that have been raised by Mr. Moffat, I just have some concerns that this will be the effective way of doing that.
Okay.
The question is, shall NDP 4 carry? Mr. Duguid.
Opposed, Mr. Chair.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler.
Opposed.
Mr. Benson.
Opposed.
Monsieur Deltel.
Contre.
Mr. Kirk.
I'm opposed.
Mr. McLean.
Opposed.
Madame Posey.
Contre.
Ms. Collins.
In favor.
Yeas pour 1 nays contre 10.
So the amendment is negative, but the issue will probably come up in our water study, so we can look forward to that. So because of the magpie, phenomenon, Magpie River phenomenon. Okay, so we'll move on to. And we'll go on to NDP 5. Would you like to move that, Ms. Collins?
I will move it, although I hope that maybe there won't be too much discussion, as it is in a similar vein to previous amendments to protect the right of every individual in Canada and future generations.
Any discussion?
The vote is on shall NDP 5 carry. Mr. Duguid.
Je vote contre.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Oppose.
Mr. Weiler.
Opposed.
Mr. Benson.
Opposed.
Monsieur Deltel.
Contre.
Mr. Kirk.
Opposed.
Mr. McLean.
Opposed.
Madame Posey.
En faveur.
Ms. Collins.
In favor.
Yeas pour 2, nays contre 9.
So the motion is negative. And we move on to Green Party proposed amendment 2, and it's already been deemed moved. So I would ask Ms. May to make a brief explanation in support of her motion.
Thank you, Mr. Chair, and thank you for the indulgence earlier to allow me to provide more detail from history. This amendment specifically to draw attention to members of the biggest change here from the text we have in front of us is to remove the words, quote, subject to any reasonable limit, unquote. I'll note that in other acts of this kind, in environmental and human rights legislation, no such qualifying language is used to limit. By the language that I've proposed here is all found elsewhere within the Act, and clearly members are very familiar with the notion of applying the precautionary principle, principles of environmental justice, polluter pays principle, principles of sustainable development, substitution, non-regression, and intergenerational equity. to draw again to the attention of members, it's quite inappropriate to at this stage include subject to any reasonable limit. That language was removed in relation to the right to a healthy environment when this bill was before the Senate. So I hope this is just tidying things up to keep things consistent. Thank you, Mr. Speaker. I did the same thing that Terry just did. Thank you, Mr. Chair.
Thank you. Discussion? Yes. Discussion. Yes, Mr. McLean.
First of all, I'll ask Mr. Moffat for the interpretation of these legal terms and how they'll impact the legislation by being inserted here, and then I'll speak to it again after that point. But I want to hear Mr. Moffat first, please.
I'd like to turn to my colleague, Laura Farquharson.
Sure, yes. So I think just to clarify, subject to any reasonable limits remained in the bill after the Senate studied it. And I think as witnesses before the committee acknowledged, no right is absolute. And that's what this indicates, subject to any reasonable limits. And so I think if you took it out, the implication it might be unclear. And as for adding the additional principles, the way that the provision is constructed, it's not an exhaustive list as it is. So other principles could be part of what's considered in the right to a healthy environment, and it would be elaborated on in the implementation framework and might include some of these principles, and that's something that could be discussed as we develop the implementation framework. I would say that at least one of the principles, substitution, is specifically related, at least from my understanding, to chemicals management, substances management, whereas this right is applying to the whole act. And so I think it might be better to just to highlight the few key principles as have been done that should be covered and allow for others to be explored through the process of developing the implementation framework.
Mr. McLean, you said you had a follow-up question.
Well, I did, because there, and my colleagues will know because I've spoken about this before, but these principles that we're talking about here have little to no legal standing in any court that I know of. And if it's true, there have been cases decided where this has determined what these terms mean on a legal basis, particularly in Canada. Things like principles of substitution, non-regression, and intergenerational equity, environmental justice. I've yet to see any tangibility around these terms. And as opposed to this committee drafting or approving legislation that will open up somebody else to interpret what we mean here, I think it is kicking the can down the road. I think we have to get precise in what we're trying to accomplish here and not just put nice words on paper, but find something that lands. So I will be saying this whenever these terms come up in this bill. These are not, as I say, tangible terms that we have any meaning that has been determined in a legal process that I know of, and I can be educated on this, but I'm certain it hasn't happened in Canada. But the meaning of this, I think, is wide open and subject to somebody else's interpretation at this point in time. Thank you.
Ms. Collins.
I just wanted to speak in support of this motion. I have a very similar one that follows, with the exception of, I think, something that maybe strengthens Ms. May, strengthens my motion in this motion by Ms. May. I think the polluter pays principle is a really valuable addition. I think something that could strengthen both of our motions would be changing the word applying to upholding. And so, if this doesn't pass, I'll likely be submitting a motion from the floor right after. So.
Madame Posey.
Oui, alors je vais...
Yes. So I don't want to come back and talk about the principe de précaution, precautionary principle, French term, because I will be talking about the definition at clause 4. But I want to tell Ms. May that I will be voting for this, regardless of the fact that in French, the principles of sustainable development, principe du développement durable, for 10 years, they're saying rather than durable, we should use viable. I took part in some of those discussions. I find that Mr. McLean is right in what he said, but for a question of principle, to see those words, the environmental justice, polluter pays, and all that, I would vote for this amendment. Ms. Taylor-Roy.
Thank you. And while I agree with what Ms. Posey and Ms. May are saying here, and Ms. Collins in the next one, I think there are differences between the ones that Ms. May and Ms. Collins put forward. And I'm looking at this as the statute, and we have the whole section on implementation framework. And I just feel like some of these things, these principles do change over time. And some of these, as Mr. McLean was saying, aren't well defined right now. New ones will be introduced as we continue to make progress in the environmental field. And I just feel like these are the type of things that we'd be better off addressing when we have time over the next year or two in the implementation framework to really address these. So that would be my suggestion on how we deal with this as opposed to putting it into the statute here. Thank you.
We are currently studying an act. We can agree with some principles or disagree on some principles, but we have to define principles in a legal text. It's not a elections program or in a speech. At this stage, for this bill, for as long as the definitions aren't clear with all the consequences this can have, because laws are there to be respected, to be applied, maybe challenged, and then judged in courts. So it's important to define the terms, which isn't the case in this current amendment. Any other interventions? Any other questions, comments? No, so then I will call the vote.
The vote is on shall PV2 carry. Mr. Dogood. Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed, sorry.
Mr. Weiler.
Opposed.
Mr. Benson.
Opposed.
Monsieur Deltel.
Contre.
Mr. Kirk.
I'm opposed.
Mr. McLean.
Opposed.
Madame Posey.
En faveur.
Ms. Collins.
In favor.
Yeas pour 2, nays contre 9.
Donc l'amendement est...
So the amendment has been defeated. And now we come to Amendment NDP 6.
And Mr. Chair, rather than moving that amendment, I'm going to move the same wording except for changing the word apply to uphold. So it will read the motion or the amendment that I'll move would be that Bill S5 in Clause 3 be amended by adding after line 13 on page 3 the following. A3, in relation to paragraph A2, uphold principles such as principles of environmental justice, including the avoidance of adverse effects that disproportionately affect vulnerable populations, the principle of non-regression, and the principle of intergenerational equity.
Just a moment, please. Okay, so so you're moving it with uphold instead of apply. Is
Yes,
that correct?
but not moving my original motion, moving the same language with uphold instead
Got
of
it.
apply.
Okay. Discussion. Mr. Dogood.
I'd like to...
Sorry, Ms. Collins, do you want to speak to your motion?
I think we've talked a little bit about it already, but I do think that naming in the bill some of these principles is important. They do appear already in SEPA, and especially when we're talking about vulnerable populations, it's so essential that, yeah, you know, I recognize that the committee didn't want to explicitly give the right to future generations, but the principle of intergenerational equity is one that I think everyone can get on board with, and wouldn't have, I think, the same kind of ramifications that that would be extending the full right to a healthy environment to future generations. And it's essential that we uphold these principles of environmental justice.
I think Mr. Duguid wanted to speak.
Can we just suspend for like 2 minutes, Mr. Chair?
Sure. We're going to suspend for 2 minutes.
Now I'm just unclear on procedure, Mr. Chair. She's put a motion on the floor, is that correct?
Yes, but the motion is not the one that's in your package.
Correct.
It has a new word.
This side will be supporting that motion.
Okay. Anyone else?
Sorry, there is a motion to change the motion.
No, the motion as it is in your package was not moved. An alternative motion was moved, which is basically identical except the word uphold is where the word apply was.
Okay. Can I speak to Mr. Moffat again, because he's previously spoken at this committee about the rights of future generations that we were trying to build into this bill. And if the principle of intergenerational equity is the same thing as we voted down earlier, I would like his input on how, his interpretation of how this is different from what he spoke about earlier about the rights to future generations and intergenerational. Mr. Moffat, please.
So I'll start, and I might need to be supported by my colleagues. The basic difference that I want to bring to your attention is the difference between giving a right to future generations versus giving an obligation on current decision makers to account for the interests of future generations. That the intergenerational equity refers to the latter concept in the way it's constructed in SEPA now. So it requires us, when we make decisions today, to consider the impacts on future generations. That's not the same as giving a right to a future generation.
Does that answer your question, Mr. McLean? Yeah, okay. Anyone else?
Mr. Chair?
Yes.
Could you just read the sub-amendment, please?
There's no sub-amendment.
It's a different motion. It's a different motion. With just one word change. Right.
Sorry, that's what's confusing, yeah.
Good. Chair, just curious for my Francophone colleagues if the motion that was moved in English. So just wanting to ensure that, I know there's been some concern about translation and whatnot, so I'm wanting to maybe hear from those who are...
How do we work with the... That'll be taken care of? Yeah, so the legislative drafters will use the appropriate French term. McLean?
Do we have a acceptable definition of non-regression? Because I've seen several different definitions when I look for non-regression.
Does anyone, actually that's a good question. Does anyone know specifically what that means? Do you have an answer to that question?
I've raised my hand, Mr. Chair, in case you can.
You don't want to get, you're not trying to, you can't help us with the term non-regression. Okay. Collins, the term non-regression. Can you hear me?
The term, I don't know if we have a formal legal definition. Laura may be able to elaborate. The term is intended to, the inclusion of the principle is intended to ensure that there is no reversal of environmental protection.
No backsliding, basically.
No diminution of environmental protection that has already been established. So it doesn't set a bar that needs to be attained, but it says once we've attained a bar, we don't move backwards.
That's right. Okay. Sorry, Ms. Collins, your hand was up, right?
Yeah, I was just going to answer the question because on the government webpage, there's examples, and it says non-regression, e.g. continuous improvement in environmental protection.
Okay. Madame Posey.
Yes. I just want to underline that in G4 there is a definition that will be proposed by the government on the non-regression principle. Yes, I understand more or less what it means. I think it's quite clear from the answers given. So, does anyone wish to speak further on this? So, I'll call the question.
Shall NDP 6 carry? Mr. Duguid.
In favor.
Mr. Longfield.
In favor.
Ms. Taylor-Roy.
In favor.
Ms. Thompson.
In favor.
Mr. Weiler.
In favor.
Mr. Benson.
Oppose.
Mr. Deltel.
Contre.
Mr. Couric.
I'm opposed.
Mr. McLean.
Opposed.
Madame Posey.
Pour.
Ms. Collins.
In favor.
Yeas pour 7-7, nays contre 4.
So the amendment is carried. We go now to BQ2. Madame Posey.
Oui, alors ce sera...
Yes. So it's quite short to present it. What we want here is to strengthen the fundamental principles for the implementation of the right to a healthy environment, because we did say that the right to a healthy environment, where it's placed in S5, does not provide a true right. So we're trying to strengthen that for its implementation. For example, administrative obligations and those in Article 2. So adhere to the principles of environmental justice, including by avoiding adverse effects that disproportionately affect vulnerable populations, the principle of non-regression, we're coming back to that, and the principle of intergenerational equity.
Oh, sorry, Ms. Collins, was your hand up?
Sorry, point of order, Mr. Chair.
It was a point of order, yes.
Okay, sorry. So you both have points of order?
I'm sure they're the same one, just that this is the same line as we amended.
So it's Mr. Couric first, then Ms. Collins, then Mr. Weiler.
Thanks, Chair, and I didn't want to interrupt, but if I'm reading correctly, this I'd question as to whether or not this is in order with the amendment that was just passed prior to this. So I'd ask Mr. Chair if that could be clarified.
I will consult on that. But they're in order.
Yeah, it would just, and it would be renumbered.
I mean, they are very similar, I'm told, but in NDP 6, there's a reference to A2, and in BQ 2, there's no reference to A2. And I'm told that you can add, you can add to any clause. I mean, it would be renumbered. I mean, they can't both be A3, but it's not. I'm told it's not out of order. It may be. It may be a little repetitive, but it's not out of order, I'm told. Ms. Collins? Was that your point of order too? Same point of order? Yeah. Mr. Weiler? Same point. So, I mean, we can vote on it. I mean, it's up to the committee to decide if they want to reinforce this idea. Anyone else? We'll just go to the vote. Okay, I'll call the vote. Oh, sorry, you had your hand up. I'm sorry, I didn't see that.
I did have my hand up. I just wanted to see if Madame Posey wanted to maybe withdraw it, given that it has almost the exact same language, except for the kind of language of uphold, which I think is strong in the last motion. Yeah, just wanted to check in with Madame Posey if she wanted it to kind of.
She said, I heard a no. I heard a no. No. Okay, so.
Given that we're told that we can have both, we know that in education it's worth repeating things so that things sink in. Yes, we have to repeat them a lot in the education system.
On va procéder au vote.
So we'll call the question.
The vote is on shall BQ2 carry. Mr. Dogood.
With reluctance, oppose.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed because I think it's covered already.
Ms. Thompson.
Oppose.
Mr. Weiler.
Opposed.
Mr. Benson.
Opposed.
Monsieur Deltel.
Contre.
Mr. Kirk,
I'm opposed.
Mr. McLean,
Contre.
Madame Posey,
En faveur.
Ms. Collins.
Opposed.
Yeas pour are 1, nays contre 10.
So the amendment is negative, and we go now to G3. Who would like to propose G3? Mr. Weiler, it's your amendment, so
Chair.
yes. Yeah.
Yeah, I think we've already dealt with almost a carbon copy of the same one, and I'm not sure at this point if it'd even be in. It would even be in order at this time. Now that
You would like to withdraw it?
well, I'm not going to move it.
Oh, you're not going to move it, right? Okay. I'm not going to move it. Yes, just a moment. Yes.
Chair,
Yeah.
I would move to adjourn.
Okay. It has been 2 hours. We'll vote. I mean, is there unanimous? What's the opinion of the room? Yes. Yeah. Okay. Planes to catch, places to go, people to see. Okay. Well, not too bad. Yes. Okay. Have a good weekend, everybody. We'll see you next weekend.
Mm-hmm.